This definitely is a hot topic, and we are so happy to have the best experts who have joined us live, both Nikhil and Aditi from Yellow, to answer all your questions about trusts, about estate planning. And trust me, even if you have no questions after the session, you will tend to have a lot of questions. That's how deep it's going to dig your brains into. Okay. So for those, our topic for the day, it's all about trusts. And we have the experts in the house. That is Aditi. Hi, Aditi. Aditi joins us. Actually, she's from Pune, but today she's in Indore and she's also trying to beat the heat. Nikhil is joining us live from Bangalore. That's Nikhil. They are both from Team Yellow. Did her talk earlier. She is the head of legal affairs at Yellow. She's a lawyer with 12 plus years of experience in estate planning and commercial law. Earlier, she has worked with Kotak Mahindra Trusteeship, MUFG Bank, and Paris Puhard and Associates Advocates. Her areas of specialty include consulting on will creation and structuring of trusts to ensure the smooth intergenerational transfer of assets, insolvency protection, estate duty protection, and more. And we also have Nikhil. Nikhil is a CA by profession, and he has spent a large portion of his 15-year career at PwC, Ernst & Young, and involved in estate planning, taxation, and M&A transactions. Nikhil is currently at Team Yellow. He is building a team of estate planning experts to provide users with best-in-class support to complement their tech platform. Nikhil is also focused on strategy and finance matters. Thank you so much, Nikhil, for joining us today. And
on trust today. But of course, before we even start the meaning of what trust really is, it's important to understand what is succession and estate planning really. You know, a lot of times when you talk about estate planning, people ask, are you talking about real estate? Is it dealing with buying and selling of property? The answer is no. Estate planning really means how your assets will pass on to your loved ones. So we'll cover the meaning. Of course, there are a lot of misconceptions in this space, so we'll clear those facts for you. Now, there are several estate planning tools which are available. Trust is one of them. So we'll, of course, give you a quick overview of what the other options are. So you are very well aware of the conversations that you want to have with your family members, what goals you have in mind, how you can achieve those. So we'll talk about those. And of course, like I mentioned, emphasis will be more on wills and trust today. And lastly, little bit about Yellow and how you can make use of our services. So to begin with, see, we as Indians were very good with this concept of saving. Nobody had to tell us that you have to save for your loved ones. So we are very good with investing the money. We're very good with buying insurance, especially with the awareness on mutual funds. We're pretty much sorted on that aspect. However, what we're not very good at is understanding that when those very assets which you have saved for your loved ones, when they pass on to them, when the situation arises, in the absence of a will or a trust, your family has to go through n number of hardships. Now, you may wonder what are these hardships? So we'll talk about that in the next few slides to tell you why is it so important to have an estate plan. Some hard-hitting facts to begin with. Approximately, there are 1,50,000 crores of assets which are lying unclaimed. And these are just financial assets. We're not even touching upon real estate. The main reason being is that families are completely not aware that these assets even exist. So naturally, they don't come forth to claim them. This is a data which was published by the Lok Sabha around 2 years back. So probably this number has ballooned much more. But that is the reason why all the more important that a family should know what assets that we have. Also, whatever property and family related disputes that are currently going on in the Indian courts, 76% of that is because of family related disputes. And you know, a large portion of this would not be there if, of course, family would have created a will to make sure that assets pass on in a proper fashion. Lastly, if everything goes well, that is, if there's no dispute, it takes around 3 whole years to complete all the asset transfer formalities. Now, you may ask, why does it take so long? In the next slide, I'll give you the exact details of what are the several hardships that families need to face. Now, what really happens when a person passes away? See, there are two ways in which the assets pass on to the loved ones. One is when you have taken the decision in your own hands and you mention that, look, this is how my assets should go. Split between 2 children, or one child gets X, one child gets Y percentage. Basically, you decide. Now, what happens when you have not taken the decision? The law decides on your behalf. See, somebody has to decide, right? How does the asset have to be distributed? Now, in this, we don't have one single law which governs each one of us. We have laws based on different religions which govern us. So, for example, for Hindus, you have the Hindu Succession Act, which deals with how Hindus are going to inherit assets of a person who's passed away. You have the Indian Succession Act, which governs Christians, Parsis. You have the separate Muslim law, which governs Muslims. All these laws uh, carve out several parameters on the basis of which assets will be passed on, which means succession is different for a male and a female. Succession is different in some cases where property has come from the father, or in some case the property self-acquired, which means you have brought it on your with your own funds. So to give you a simple example, if a Hindu male passes away, his mother, his wife, and his children are equally entitled to the assets. In case of a Christian male, 1/3 belongs to the spouse and 2/3 assets goes to the parents. So several factors are taken into consideration. Now the problems only begin from here, because today asset transfer is much, much tougher. It's not how it used to be much earlier. I'm sure most of you would have seen when your parents passed away, asset transfer was much simpler. Today, authorities will ask you to produce a number of legal documents, including something called as a succession certificate or a legalese certificate, or I don't intend to scare you with all these names, but essentially they're known as different documents in different parts of India. But important aspect to remember is that you now need to prove that you are the rightful legal heir. So that document will show that yes, XYZ, these are the rightful legal heirs. Only then the asset transfer takes place. Now, the whole process is extremely stressful, it's cumbersome, and of course, it's also very expensive. But all of this can be easily done away with. You can avoid all of this if you have a will in place. Now, we saw there are a lot of misconceptions which are there in this space, so we'll quickly take a look at that. One of the most important misconceptions is that if you have appointed a nominee, then you don't need to, create a will. Now, essentially, it's important to remember that for most asset classes, your nominee is only a caretaker or a trustee of the asset. This means that your nominee does not become the owner. I'll give you a quick example. If I appoint my sister as a nominee for my bank account, if I pass away without a will, then she can go to the bank, she can access the amount, but she can't spend it because as per law, she's not the owner. If I, being a Hindu married female, my husband and my children will be the rightful legal heirs, not my sister. So she's supposed to give the money to them. Now, this is when all the confusion happens, because most nominees think they are owners. You don't need to be of a particular age or unwell in order to make a will. Also, a will does not need to be made only by a lawyer. If you have, help such as Yellow app, then even you can do it by yourself. It's also really easy to change your will. In fact, we recommend you to take a look at it once a year to make sure it's in line with your goals. A will does not have to be registered or notarized or stamped as per law. A simple plain paper, you all you need to do is be 18 years of age, sound mind. You need to sign it. You need to have two more witnesses to the same, and that becomes a legally valid will. We've already gone through how a number of family members become the owner of the asset. It's never just your husband or your wife. So, especially if you want to make sure that after I'm no more, my wife should be taken care of or my husband should be taken care of, then a will is the only way. Otherwise, it gets distributed amongst all the family members. You also don't need to be of a particular net worth in order to make a will. Even if you have one bank account, a will is a must, because your family will have to go to court and get all these paperwork done if everything is not in order. Also, you don't lose control over your assets just because you made a will. To give you an example, if I write that a flat that I own will pass on to my husband, if I write that in my will, only when I'm not around will the flat go to him. So basically, your will comes into effect only once the person is no more. Until then, you can change your will as many times as possible. And lastly, making a will is really simple. It's easy. We've broken it down properly for you. So you don't need to get scared about this topic. And we encourage all of you to have one in place to avoid all the hassles. Now let's take a look at what are the various options that you have. Most important amongst all of these is a will. The reason being is that it is it does not replace or substitute a trust or a gift deed or any other instrument. If you opt for a trust or if you opt, let's say, for a gift deed, it will always be in addition to a will. See, the reason being is that till the time we are around, we'll need some amount of money to take care of ourselves. So till that time, you'll always have something with you. And the will is that last document which you can have in place where becomes into effect only once you're not around. I mentioned earlier, but I'll give you a quick recap. Really easy to create a will. You mentioned detail about yourself, the assets, beneficiaries, basically to whom the asset should go to. You need to be 18 years of age, sound mind, that is, you're capable of understanding your actions. And you need to physically sign it. Digital signatures are not yet permitted on a will in India. Get two more people, witnesses, preferably independent, who will sign the will, and that becomes a legally valid will in India. Now, with a will, there are bullet payouts which are made. For example, if I say that 5 lakh rupees will go to my child when I'm not there anymore, there'll be a lump sum payment which is made. But in some cases, I may want to add in certain terms and conditions. Because, let's say for a teenager to receive 5 lakh rupees in one go may potentially be a recipe for disaster. So I may want to mention that when my child turns 25, every month he should get 50,000 rupees. Or when my child turns 30, he should get 75,000 rupees. Terms and conditions can be put via a trust. So, of course, we'll get into more details, but I'll just give you an overview. Trust is an entity which you can have in place where you identify certain people known as trustees who will manage the money that you want to put in. And of course, simply put, there will be beneficiaries who will be reaping the benefits of the trust. So basically, it's a separate entity that you create which will help in the management of your money. And of course, making sure that it reaches the beneficiaries at whatever stage you want. So you can manage and administer the assets well to make sure that your end goals are met with. Of course, we'll talk about trust in detail later. Gifting is a very popular option. Most of you may already be aware of it, especially with the Vijaypat Singhania case, Raymond's, where he gifted volume of his assets to his son. Later, relationship between them have soured, and unfortunately, we all know how he did not even have a roof over his head. So gifting is okay as long as you don't gift a volume of your assets. Make sure you have enough to take care of yourselves. And especially with respect to senior citizens that we have today, we have a law called as the Maintenance and Welfare of Senior Citizens. So you can make use of that law. Basically, the law says that if you're gifting any asset with the expectation that they will take care of you, just make sure that you add that condition in the gift document. Basically, it should be written and recorded. So in case if the family members don't take care of you, you can actually take the gift deed, basically revoke the gift deed and take the assets back. Coming to joint accounts, people usually think if I own a joint account, bank account, or if I jointly own a flat with my husband or wife, after they're not there, it belongs to the survivor. That's not true, because as per law, let's say if husband wife own the asset together, husband passes away, 50% of his share will pass on to his legal heirs, which means his mother, if she's around, wife, and children. So imagine his 50% gets divided into so many other fractional shares. That's when it becomes a huge problem. Who wants to sell off? Some person doesn't want to. Creates a lot of issues. So just make sure, even if you have a will, even if you jointly own an asset, both of you need to write a will with respect to your share. Lastly, coming to nomination, although technically not an estate planning tool, but nominations are important because asset transfer becomes much smoother. So what we recommend at Yellow is that you appoint your beneficiary, whoever you want to ultimately receive the asset, and make sure you also add that person as a nominee, so it's all synchronized. Now, so far we've seen what are the challenges that come in when a will is not in place. We'll quickly summarize why is it important to create a will. We've already spoken about this. It's the most important step towards creating of your estate plan. When you have a will in place, you bypass or you overrule the personal laws which apply to you. So no Indian Succession Act, no Hindu Succession Act will apply if you have a will. Asset transfer to the next generation becomes much smoother. So you don't need to run to courts to get all the paperwork done. Also, we saw 1,50,000 crores of assets are lying unclaimed because families don't know, right? How many of us really know who our family members are banking with? So with a will, when you mention your asset details, your family will be able to go and claim rightfully what you saved for them. It also prevents family disputes because your family will know what you really wanted rather than going to courts and having it interpreted over there. When it comes to minor children, you can pass on the information to your children if they have children that with a will, it's one of the very important documents through which you can appoint a guardian for your loved ones, especially when children are small. And lastly, when you create a will, you have the power to choose. You can decide who should get what, and accordingly, you can decide that if some child needs more, or if some child needs extra guidance, or if want to give something to charity, all that can be planned through a will. Some of the quick recommendations that we have to make sure that your will can be a robust one. A quick recap. You already know 18 years of age, sound mind. Mention details about your assets in a clear, simple way. See, you don't need to mention values. Generally, people are very afraid of how can I write about my assets, but all you need to do is mention so and so bank account number, so and so branch, and of course bank name. That's it, because values keep changing from time to time. If you're so particular, just mention the last 4 digits of your bank account number. That is also fine, but it's important that families know that you have an asset. Get it signed. 2 witnesses also need to sign it. Preferably, they should not be interested in your estate. And lastly, appoint an executor. Executor is a person who's in charge of making sure that the will is executed, assets reach the beneficiaries. So with this, make sure you appoint not just an executor, also a backup executor. When you don't appoint an executor, you need to again go to court to have someone appointed. Quick good to haves. You can video record the execution of the will when you're signing it. If you're comfortable to read out the will in front of your family members, you can do that. Acts as a good, important evidence. Recently, courts in India have also encouraged that yes, technology should be used to create evidence. Get a doctor's certificate, which will show that you're of sound mind, you're mentally fit in order to create a will. Do register your will if you're dealing with any immovable assets. See, in India, as I mentioned earlier, registration of a will is not mandatory. However, certain parts of India, they rely more on a registered copy of a will. And that is why, if you're dealing with real estate, do get your will registered. We at Yellow help with registration of wills as well. So, in case if you need help, you can reach out to us. Please keep all your ID proofs updated. Seems like a really silly point to talk about, but we have a few clients who have a mismatch of names, and asset transfer became a huge problem later on because there was a lot of mismatch with names. Just make sure everything is updated. Also, update your will from time to time. Like I mentioned earlier, once a year, revisit it so you know it's in line with your wishes. And lastly, please keep your loved ones informed. At least tell somebody that you've created a will. Also, one tip we'd like to share at Yellow is please do not save your will in the locker. Lot of people think of it as a very confidential document and they put it in the locker, because in order to access your locker also you'll need your will. So you can put it somewhere safe at home, or you can give it to your executor, a friend, etc. Please don't keep it at home. With this, I'll request Nikhil to take the presentation forward from here. Nikhil will be covering trusts in detail.
Thanks, Aditi. So, let's understand when is a trust that needs to be looked at. Aditi did kind of touch upon it in the beginning, where, will does not give you the entire perspective or meets all your objectives, is where you look at a structure like a trust. So what is a trust in a simple, if I were to put it in a very simple terms, trust essentially is an obligation or a contract between the person creating the trust, called as a settler, and the trustee, to say that, hey, these are my assets that I own. Please park it in a structure called as a trust for the benefit of the beneficiaries. Basically you provide certain wishes that you want to in terms of how your asset needs to be dealt with. You provide these wishes during your lifetime, and these wishes are to be executed or given effect to by the trust during your life and post your life, so that you can see how the structure is functioning during your lifetime, and also be rest assured that these wishes will continue to be given effect to when you're not around. Well, that's broadly what we look at as a trust structure. Now, what are the benefits of having a trust, right? One, of course, trust helps you with the overall, expediting the overall asset transmission process. The reason being that even in a will, when a will is set up, the will comes into the effect post one's lifetime, right? Which would mean that assets in your name, be it bank account, demat, even properties, needs to move from your name to your loved ones. There's a transfer of asset that needs to happen, right? In a trust, because during a lifetime you already transferred these assets into the trust. Now you may or may not be a beneficiary, but your loved ones are beneficiaries to the trust structure, which effectively would mean that when you're not around, already assets are with the trust, which would mean that you don't need to go to sub-registrar's office or go to banks, other financial institutions for asset to transfer, because the trust now holds it under its span, and beneficiaries who are part of it continue to receive benefits. If you're not around, you're removed as a beneficiaries. Future generations that you provide for, they get added as and when new loved ones are born, and that way the structure kind of continues for multi generations. Basically, title transfer is not required, and which would mean that families get access to the assets immediately from the time an event arises, right? That benefit is not there in a will. Of course, with a will, asset is end of the day available to the family, but with some sort of a delay. With the trust, that becomes extremely seamless. Trust also is a effective tool to ring fence from any potential financial exposures. Now, what are these financial exposures that we're talking about? It could be that you've given personal guarantees, or you're in, you could be in running a business, and there are potential exposures that may come your way, be it in a, say, a highly leveraged business like a what you call as infrastructure real estate business, where the quantum of debt taken is very high, and so is the case of a potential liability. Or it could be in a professional businesses, be in medical or other fields, which could also expose you to a certain liabilities. So how do you ring fence yourself from such liabilities? Should something come your way, your personal assets are not exposed. How do you do it? Is by having a trust in place. Also, situations like, you know, uh, y- you have family members who generally, if you don't do anything about it, God forbid, say their marriages, you get into a situation of a separation, etc. At that point in time, the assets in their name are part of all conversations with respect to settlements that may come into the picture. Here again, when the assets are part of the trust, you can ensure that your assets are available only for your bloodline. Separations, extended families, all of it can be kind of fully protected. Basically, assets, since it's part of the trust structure, not in one individual's name, therefore, the assets pretty much doesn't expose in terms of one's potential liabilities. Liabilities, like I said, could be business risk, could be regulatory risk, could be relationship risk. All of it can be fully, kind of protected, and therefore your bloodline or your future generations will have access to these assets, and any such risks are fully protected. As basically your wealth is shielded from any such liabilities. Incapacity planning, that's a very important benefit of a trust. In a will comes into the picture only on one's demise. But incapacity is a situation we are talking about where, sorry, you are physically or mentally incapacitated. And that point in time, you're not in a position to enter into contract or deal with assets, right? Because that legally you're not in a capacity to deal. At that point in time, what happens is that your assets are fully frozen not only for your basic medical needs but also for your family's lifestyle needs. And we have seen situations where family members have gone into coma, and assets are frozen, and we had to get specific approvals from court for release only for medical needs. And courts don't give a blanket approval, but piecemeal basis or for specific needs is where they release, and that only for medical purposes. They don't release money for families' well-being, right? And it's very difficult to do that. And therefore, if you don't want situations where, in case of an incapacity, um, your medical or your family's lifestyle needs are not to be disrupted, then trust becomes a very, important tool, because assets are already part of the trust structure. Should something happen to you, you step aside. Others in line can come and take charge of the trust operations, and ensure your medical and family's lifestyle needs are fully taken care of. Avoiding disputes with respect to family succession is a very important benefit of a trust. While will gives you complete clarity in terms of how asset needs to be distributed, unfortunately, a will can also be, contested. It doesn't mean that will is not important. Even if it contested, with the checks and balances that Aditi spoke about, having making it robust, it'll ensure that your family comes through, but it comes with a cost, which is time delay for access to the assets. But in a trust, once the assets are part of the trust, your trust document becomes the Bible for how the asset needs to be dealt with, which would mean that none of your inheritance succession laws, nor does your testamentary issues which is arising from will, etc., comes into the picture on how these asset needs to be dealt with. Therefore, what you have laid down in terms of how the asset needs to be dealt with in the trust deed, that becomes the law of land, and the asset will be dealt with in so and so fashion. And we have seen a number of cases where assets transferred to a trust are out of any such litigations. Very much so, because you have already given the clear guidelines and instructions on how these assets needs to be dealt with. But of course, the caveat here would be that if the asset is already subject to litigation, moving that into a trust doesn't help. Only clean assets with clear title moved into the trust will be protected from any potential liabilities or disputes in the future. Trust also helps you with conditional distribution of assets, be it for minors or for special family members. Here we are talking about aspect of one being that if you have minor children, transfer of assets to them will be a question mark, because they can't for one hold it in their individual name. Of course, you have minor accounts, but it needs to be manned by your maintained by a guardian. Potential misuse possibility. Second is that even at the age of 18, do you want minor children to hold any sum of rupees, right? And that clearly could be a potential recipe for somebody being influenced and potentially destroying the wealth. And therefore, if your wish is that if you want to pass on the assets to minor children, even at the age of 18, they don't actually gain access to the entire asset, but only for their specific needs. Could be medical, of course, but their lifestyle, education needs. But then say, after the age of say 25, 30, whatever you think is the right mature age for them, you want to see or give them the access to the entire asset, right? That is something which is possible only through a trust, because in a will, on demise, you have given your wishes saying that so and so asset needs to go to XYZ. Assets go as a bullet payout to them. You can't have a condition on how these assets needs to be dealt with. And that is only possible through a trust. Business succession is a very important benefit for a trust. There is statistics that if you've done nothing by three generations, the family businesses can actually go down, right? Because it's the way it is, right? As in the first generation build the business, they know exactly the struggle with which they went about. Second generation, to some what do you call to some extent, they actually have access or visibility of how the previous generation built the business. But many a times the third generation are more or less insulated from how the business was built. And therefore, if the messaging, the ethos, etc., is not passed on and right structure is not put together, that's when there are going to be rifts, because more so because of the messaging not being brought down to multi-generation, but also of the fact that the first generation to the third generation, there are expansion in the family numbers, right? Members, and therefore, who should be the one to lead the business? Is it merit based? Is it age based? All of it, if not defined, could lead to litigation and conflict in the family, resulting in business being suffered, right? And we have seen multiple scenarios, and therefore having a clear plan of how business succession happens is very important for the continuity of family businesses. Estate duty planning is the last benefit of a trust. Estate duty here refers to inheritance tax, demise tax, estate duty, all nomenclatures are used. Basically here, governments charge, family members on demise of a person. Basically, if I have certain assets, should I pass away, before my family members gain access to these assets, they levy a tax, saying that these are received by way of inheritance. Before that, a certain tax needs to be paid. This tax, is to the extent of 40% in UK, US, Canada, Australia, and so on and so forth. India also did have an estate duty law, which got abolished in 85, but there are talks in terms of this being reintroduced. Basically, a trust becomes a very important tool for planning with respect to estate duties, both from a outside of India perspective, because family members who are situated outside, they are usually subject to estate duty even on global assets, and therefore having a structure for Indian assets becomes very important. And more so, this could potentially be a good vehicle to ring fence yourself or protect your assets from potential estate duty laws that could be introduced in India. Right? And these are the reasons why it's important to look at a trust structure. But if these are not of a consideration for you, then will is a good, instrument that will meet your objectives. But having said that, Aditi did talk about it earlier. I'll also reiterate it again. It's, will is a foundation of any estate planning tool. We need to use other tools like trust, etc., as an add-on, right? Will has to be there, but trust is to meet those additional documents. So it's not a question of will or trust. It's a question of saying, do you need a will? Answer is it's always yes for everyone. But trust is something which you need to evaluate on a case-to-case basis. If so, it's will plus a trust for your family so that your objectives are fully met. Moving on, we'll also talk about taxation of trust. Before that, we'll also spend a couple of minutes on different types of trust, right? In India, broadly, there are two types of trust: revocable trust versus irrevocable trust. The basic difference here is that in a revocable trust, if I am the person creating the trust called as a settler, if I transfer the assets into the trust, I have the right to take that asset back. I can revoke it, take those assets back in my name. That is called as revocable trust. In an irrevocable trust, if I, as a settler, transfer the assets into the trust, once transferred, I can't take these assets back, right? That's the difference between broad difference between a revocable and irrevocable trust. Why use revocable or irrevocable trust is basically a question of saying what is the objective that you need to meet. If you're in a very simple, thumb rule, if I were to put in, if your objective is very simple, so that your assets just need to seamlessly pass on from you to your loved ones, including planning for incapacitation, controlled transfer of assets or a conditional transfer of assets, etc., then a revocable trust will do the job. But if your objective is to plan for ring fencing of your assets from any potential liabilities, estate duty planning, anything to do with protecting from external forces, then an irrevocable trust is the way to go. I've made it very simple. It's not such a straightforward analysis, but from a broad context perspective, that's how you need to look at it. And why is revocable versus irrevocable relevant? And sometimes, even if I were to step back, there's always a confusion in terms of clients coming to us and asking, and who have done some bit of research on types of trust in India. They always feel that irrevocable trust is the most flexible trust wherein you can make as number of changes. But in an irrevocable trust, if assets are transferred, it's cast in stone and nobody can change anything there. Actually, that's not the the way you look at it. Like I said, it's the power of the settler is where determines whether it's a revocable versus irrevocable trust. But irrespective of the nature of trust, depending on how you draft the trust document, both revocable and irrevocable trust are extremely flexible. You can make as many changes as possible as long as you meet. Basically, it's you need to lay out exactly what is there, right? The beauty of a trust is that there are broad boundaries that one need to look at from a trust law standpoint. Apart from that, it's a plain paper, right? You can definitely capture all your wishes in a nice fashion. Our role as an advisor comes into the picture only to advise to say, are these rules or guidelines that you're framing, is it enforceable, not enforceable? What you need to capture in a trust is more so from an enforceability standpoint, because enforceable trust guidelines will make whole context very what do you call ambiguous and resulting in conflict. Idea would be to remove as much as possible possibility of conflict in a trust so that there's no litigation potentially in the future. Now that context is set in terms of revocable versus irrevocable. Let's also look at what is the tax implications for a trust in India. Here what we have done is we have broken into three parts. Basically the event based, right? To say what happens when the settler passes assets into the trust. Second level is that the assets now part of the trust, various incomes generating here. How is the taxation, in taxation, how these incomes are taxed in India? And third is that once the assets are taxed, any further distribution to the beneficiaries, how is it taxable, right? Our context here will be more from India perspective, and any implications for overseas jurisdiction needs to be separately evaluated. So from a first leg, right, in terms of what happens when you move assets into the trust, whether revocable or irrevocable trust doesn't matter. When a settler transfers these assets into the trust, as long as the beneficiaries to the trust are relatives as per the Income Tax Act, the the transfer into the trust is fully tax exempt, which would mean that there's no tax implications as a transfer of trust. But this purely from an income tax perspective, not from stamp duty. Stamp duty for financial assets, there is a very minimal, about 1,500 rupees per crore, which is levied. Very nominal cost that needs to be paid. But when it comes to real estate, Unfortunately, the sub-registrars levy it as if it's a normal sale. And therefore, even though there's no consideration, the transfer of properties or immovable assets into the trust will be subject to stamp duty at base, depending on the jurisdiction where the asset is. For instance, in Bangalore, it's about 6.56% that needs to be paid on the government value. Of course, in various jurisdictions like Telangana, etc., there is also a good arbitrage between the actual fair market value and government rate, but it's a government rate that you pay the stamp duty on. Now, of course, is there a planning with respect to real estate? Yes, there is a planning available. Basically, what you need to do is break or bucket your assets into 2, 3 parts, right? One, to say that are these real estate that you own meant for your investments? If so, are you monetizing it in the near future? If so, once you monetize, you can move the cash or the proceeds into the trust, which without any stamp duty. That is point number one. And future assets can always be purchased at the trust level. Second scenario is that if you have assets where the value is very low, but you know that these can balloon, or like I said, in Telangana, the government value is way lower, but the fair market value is very high. In that case, you can do a cost benefit analysis to say that, can I move the assets into the trust today so that the growth happens at the trust level, and therefore it is fully protected and covered at the trust. That's a analysis one need to do. If it makes benefit there is benefit from the cost that you are incurring, then it makes sense to move the assets into the trust by paying a small stamp duty. The third scenario could be potential litigation. If you know that your assets could be litigated, but today you have clean title, then it's a call that you could take to say, let me bite the bullet, pay the stamp duty, and move the assets into the trust so that tomorrow my family doesn't have to fight the court battle before they gain access to these assets. A classic example here is a case of one of our clients, wherein he knew that his will be contested by his siblings, and therefore he took the call to move all his assets into the trust in such a fashion that when he is not around, his loved one doesn't need to go through the court battle because he has clean title of the assets today. Once moved into the trust, now his beneficiaries can easily access these assets and he doesn't have to fight the court battle. And therefore, that's a call one could take. And the last category could be situations where these are house or a property that you are living in, or ancestral property that you have received, which you don't see a potential value growth or litigation. In that case, there's no point paying stamp duty today. You could definitely move that into the trust by virtue of your will, wherein your will, instead of saying it goes to a certain individual, it can go into my trust. And that way, when assets are moved by virtue of your will into the trust, there's no stamp duty as per current law. That's how we deal with moving assets from the settler to the trust. Once the assets are part of the trust, the nature of income is what needs to be looked at. The various natures could be either rental yield, dividend, interest, capital gains. All of it will be taxed as if it is taxed in the individual name, like in capital gains at 10, 15, 20, 30%, depending on listed, unlisted, short-term, long-term. Similarly, rent, dividend, etc., will be taxed at 30%. Plus surcharges depending on the quantum of incomes at the trust level. Once the assets are subject to tax at the trust, now a small aspect that you need to look at is that in a revocable trust, this incomes will be clubbed in your books itself, and therefore if I as a settler pass on the assets, though the income is generated at the trust level, I have to take that income, add it on to my other incomes, and then pay taxes. But in an irrevocable trust, the trust pays the taxes basis its own PAN card, right? Now, whether the settler pays or the trust pays the taxes, once paid, any distribution thereafter to the beneficiaries is fully tax exempt. Now, key point here is that if the beneficiaries are tax residents of India, then it is fully exempt. But if the beneficiaries are tax resident of an offshore jurisdiction, then the implication in those jurisdictions needs to be separately evaluated. But what we have seen in our experience is that in those jurisdictions, though it could be taxable in an offshore jurisdiction, the important fact would be that whatever tax paid in India should be available as a credit. Therefore, say if the tax rate in India is 10, a tax rate in US is 20, then the maximum tax that you'll end up paying is 20, wherein you also take in effect the credit of tax paid in India, which is 10, and pay additional 10 in US to ensure your 20 is overall met. Therefore, there's no double taxation per se that arises. usually it's only a whichever jurisdiction has the maximum tax rate, that will be the overall tax cost.
So someone's asking, I have created a will with everything made clear. Is it okay if I don't have a trust? You can just explain it in short for those who didn't missed that bit. Yes or no?
Yeah, so like like we spoke about trust, right? Trust is more an objective-driven structure, right? If your objectives are not met through a will, that's when we look at trust structure. Will is something which is of paramount importance. Good, the fact that the trust will is already done, so therefore that is taken care of. But the aspects that we spoke about, right, the benefits of a trust, be it for incapacitation planning, incapacity planning, or ring fencing from potential liabilities, or ensuring that there's no time delay, but families get access to the assets immediately. If some of these aspects are something that are of importance to you, then trust makes sense. Otherwise, you don't need a trust. A will is good enough.
Thank you. There's another question. Is a will better than a gift deed for handing over a property?
This is a favorite response for Aditi always. So I think I'll leave it.
Yes. So honestly, it all depends on the goal with which you uh, intend to achieve. I'll give you a very simple example. See, I already mentioned earlier, gifting, you should not gift all your assets, because we already have a case, Raymond's, Mr. Singhania. There's enough material out there how he really went through hard times. Now, if you want to, let's say, I'll give you an example. If you have a daughter that you want to make sure that she gets her share, how much that is during your life itself, then maybe you can have a gift deed with respect to that asset only. Having said that, a will cannot be replaced. You have to have a will, and your gift deed will sit on top of a will. So it's again not about this is good or this is bad. It's about the goal and, of course, what you intend to achieve.
And just to add on here, the point that we as estate planners vary is that relationship could be extremely great at the current moment, but we have seen things turn in no time, right? And therefore, your asset going out of your control is not a good scenario to have. We always suggest our clients, it's your asset. Families will gain access to these assets no matter what, as long as they have the visibility of what these assets are. Do that through a will, but you don't lose control of your asset, because once you lose control, then you are at their mercy, and that's something which is not a good fact pattern to have.
The question along with that is also, will I have to pay additional if it is a gift deed versus a will?
Yes, you have to pay some amount of stamp duty on a gift deed. That depends on, one, where the property is situated, and of course, what is the relationship. Because in India, we have different states have different stamp laws. So depending on the relationship as well, the stamp duty differs.
Okay.
Usually for relatives, it's a a subsidized rate as low as 5,000 rupees that we see in Karnataka, and in Bombay it's about 1%, in Telangana about 2%. So the numbers kind of vary, but it's always lesser than the typical sale value.
Okay. One last question from what I have, then we'll move on to the chat box. What is the cost of creation of a will versus trust?
So creation of a will, you've seen the cost, right? If you're using our platform, then it is very, very, very pocket friendly, because there's no human intervention here. It's the system generated, but of course, very detailed, customized, legally valid document that's coming your way. But with a trust, like I said, it's a high touch point, good amount of conversations. We personally get involved in, the whole process of creating a trust. In our experiences, anywhere between 4 to 8 weeks work, wherein you have multiple detailed conversation with the families, draft the whole document, understand what is the specific requirement, guide them in exactly what is needed. And after that, a detailed document comes your way, which could be one, two, multiple trusts. It all depending on what's the objective, right? And therefore the pricing can go, depending on what is the effort that we need to put, right? Simple point to mention here is that if you are engaging with a client for 6 to 8 weeks, basically even assume how many hours just put a percentage of time that we need to spend, that's going to be the cost. I don't want to throw a number here because that's something which we can chat on a one-on-one basis. But obviously, it's relatively higher than creating a will.
Right. I think that explains it. Thank you. Now we are moving on to questions that we have in the chat box. This is from Chandar. Is the trustee a third party or from family? Can the beneficiary, in this case my children, also be trustees?
So basically, it again depends on one is the goal you intend to achieve. If you have, okay, let me put it this way. There is no bar as per law that only a family member needs to be trustee or a third party needs to be trustee. It all depends again the goal you intend to achieve. To give you an example, in some structures where we're planning for estate duty, especially when citizenship of other countries are involved, initially there are family members who are trustees, then they also bring in corporates who are trustees. So there is no embargo to answer the question. Also, yes, your beneficiaries can also be trustees. So again, if your goal is to, let's say, estate duty or ring fencing of assets is your goal, then we generally recommend a different structures that you have independent parties. Otherwise, if your goal is simply to make sure assets are consolidated in one place, then yes, the same person can be trustees as well as beneficiaries.
I think there are two questions to Marjorie. One, of course, will we have spoken about, but a very interesting point she had highlighted, saying that in case one of the beneficiaries is a spendthrift and is likely to exhaust what is inherited in a short time to transfer my assets, should we look at trust? Definitely, yes. That's the conditional distribution that we spoke about. You can, in a trust, the good part is that in a will, like Aditi said, it's a bullet payout, right? In a trust, you can put a tap on how much you need to release on how the funds needs to flow. Basically, a trust helps you conserve the assets for a long period and available for multi-generation. In a will, it doesn't happen. So yes, one of the conditions, reasons why we have seen family members come our way for creating a trust is in situations like this, they don't trust their kids in terms of how they are, mature to handle assets, and therefore want to release control of assets at a later point when they think they are, mentally mature. Because age is not the age, what do you call the factor for considering somebody as mature, right? Even at the age of 18, there are people who are extremely mature. Even at the age of 30, there are people very mature. So it's all about what you feel is the right age for releasing control. So trust becomes very important.
is from Rukmini. She says that does the trust have to be necessarily registered? Are the assets under the trust necessarily transferred in the name of trust? Also, she asks, are the income tax rules different for a beneficiary under a will and a trust?
Yeah, so in a trust, you don't need to necessarily register it, depending on the nature of assets that you transfer into the trust. If you have to move real estate into the trust, then it has to be mandatorily registered. If you're only having financial assets, then there's no need to register the trust. That's point number one, right? Now, the second part of that question is that are the assets under the trust necessarily transferred in the name of the trust? Yes. Trust has its own separate PAN card, bank account, demat account, and all of it. So therefore, the transfer happens into the trust and in the name of the trust. But of course, it's represented by the trustee for all the actions. Like, not the right example, but like a company where company is not, while it's in the name of the company, it's the directors who represent. So trustees represent on behalf of the trust. From an income tax rules perspective, there's no difference per se on, it's, I think we need to break it down differently. When you hold the assets individually versus holding the assets through a trust, there's hardly any difference. It's more or less the same. But from a distribution per se, when you look at it, is there a difference between for the beneficiaries from a will versus a trust? In a trust, when the taxes are paid, beneficiaries receive, and there's no further taxes as long as the beneficiaries are in India. In a will, because the assets are transferred in your name, now you start paying taxes. Of course, at the time of receiving the assets, there's no taxes in your name because today there's no inheritance tax in India. But once received, these incomes arising at the trust at the individual level will now need to be paid at your individual level. Therefore, any capital gains, rental yield, interest, etc., you will pay it at your individual name, and therefore taxable in your name. But when it comes through a trust pays the taxes, and you receive the post-tax amounts in your name, and therefore there's no further taxes in your name. If I have to, in a simple fashion, respond to this, whether you receive from a trust or whether you hold the assets in your individual name and pay taxes, you're indifferent. You're not worse off or better off.
Rukmini has a question, which is better, a gift deed or settlement deed in case of property?
So we've sort of again touched upon this partly. Again, it all depends on your goal. If you want something to be passed on to your loved ones right now, you want to make sure you don't want to be dependent in the future, then yes, you get a gift deed done. Now, when it comes to settlement deed, around Chennai, they call it as a gift deed. They use it synonymously as a settlement deed. But our stamp laws sometimes refer to settlement deed also as a trust deed. But again, just to answer your question, there is no good or bad. There's no right or wrong. It all depends on your goal. Once you have identified that this is what I want to achieve, accordingly, estate plan is to be sort of planned.
Just to add on to what Aditi said, very important the point that she said in Tamil Nadu, Chennai, etc. A settlement deed is more popular because earlier gift deed was subject to a heavy stamp duty, and settlement deed was subject to a very minimal stamp duty, and that's why it's very popular. In effect, both does the same. In a settlement deed, you invoke a non-existing dispute and then settle it, so that you pay lesser stamp duty, but in effect, you're actually gifting the assets to the other person. So therefore, if you don't want to be in the shoes of a Singhania, gift only to the extent you want to gift, but keep control of all the other assets in your name.
Hope that answers Rukmini, and Rukmini is from Chennai. So I think you did
That's why it's
mention,
very popular there.
Yeah, where they are
Yeah,
from.
I was more concerned about the stamp duty portion.
Off late, there's no difference. I think stamp duty for gift deed is the same as settlement deed in Chennai now.
Okay, right. Thank you.
A question from Preeta. How can you safeguard the trust so future generations cannot dissolve or sell it?
You want to go for it, Aditi?
Okay, sure. So when it comes to a trust deed, Nikhil has already pointed out earlier that your trust deed is your charter document. So basically, you can add as many checks and balances to make sure that how the trustees are taking care and administering that money, or at what point can distributions be made, what are the decision making powers that the beneficiaries have, can one of them, rather do one of them have a right to approach the trustees and dissolve the trust? Now you can give such a right, and you also may not give such a right. So again, that is why it's very important that you choose a person who's doing your trust, who's very thorough with this, because it's very important that proper time is spent. Literally, we've prepared documents which are like 50 pages because we want to make, not because we lawyers love to add the legal jargon, but it's important that the document is robust enough so that nobody can pick out the loopholes. At the same time, it's flexible enough that some generations can also relate to the situation.
I think
Yeah.
at least with this session, by now people are clear. Earlier there was that fear of anything legal is going to take the rest of my lifetime. But that's made things simpler, especially thanks the way you all have broken things down. Sorry, Nikhil, did I cut you off?
No, I was just adding on to one more point here is that, sometimes the way it's also about, see, our, approach is more not to say that, do this, do that, right? We don't advise on what you need to do. We actually try and understand what you want to do, and we give you a direction in terms of how to give effect to those, right? Questions like these, many times we get these questions. Sometimes we also try to see what is a more practical approach to say that, do you not want to dissolve the trust? What is the reason why you don't want to dissolve the trust, right? Your objective could be to say, I want to pass it on for multi-generation. That's why I do want to dissolve the trust, right? Or I don't want to sell a property. Basically, to say they sell the property, use it, they blow up the money, and now it's gone, right? Therefore, we try to understand fundamentally what is that you want to achieve. It's not that you have a attachment to a certain property. It's more to see what exactly do you want to achieve, right? Simple example for another client of mine, wherein they said they should not sell more than 51% of their business stake. Why? Because their business is providing the cash flow for the family, and they want to run it for multi-generation. So if you sell the business, obviously the cash flow is gone and family can blow up the money, and therefore this will not survive for multi-generation. The solution is very simple. It is not that they had attachment. Of course, they have a attachment to the business, but sometimes you may have to sell the business because few years down the line, you don't know if this business is relevant. It could be a vital. You may want to sell it. The idea is to not ensure that family is able to pull out this money, but reinvest into a new business, which again becomes a cash cow.
Yeah.
That is the kind of advice that we provide so that it is available. But end of the day, we try to meet the family's objective.
Much needed. Yes. This is the last question for the day. Marjorie says, I also asked whether is it possible to have a mix of will and trust, the latter applicable only for the spendthrift that she was talking about, when transferring the assets after death.
Definitely, like we said through the conversation, will is something which has to be done, right? Beyond that, for certain objectives to be met, you want to create a trust, yes. So basically, if you have, I'm not sure the fact pattern here, say you have 2 children, one you're absolutely confident that you don't need to worry, that child can get access to the assets through a will so that they have complete access and do what they want to do. But with respect to the other child where you want to control, you want to put a trust in place? Yes. In fact, we have done this recently. We did this for a family, not to do with spendthrift, but there are some addiction issues with certain child, and therefore they don't want money to go to them so that it goes for the wrong purpose, right? And therefore they wanted to control in terms of when the assets are distributed, so that after a certain age, then let them get access. For now, at least, let the rehabilitation happen. So that way we have put together a structure for the family.
Chitra, I have received one question in my direct chat. A gentleman has asked, his wife passed away 2 years back and he has only one son. Does he need to make a will, or his son automatically gets his assets and cash at the bank? So sir, that's a very relevant question. Irrespective of the family which exists, we always recommend you to have a will in place, because the banks and the local authorities don't know that you have only one child. They will still ask him to produce the legal heir certificate and family tree certificate and whatnot in order to prove that this is the only legal heir which is surviving. So irrespective of, this is actually a very common question we get, is that I have only one child, do I still need to make a will? So the answer is yes, please have a will in place. Of course, additional steps that you can take is make sure that his name is updated as a nominee in your bank accounts and demat accounts, etc. So that asset transfer is much smoother. But yes, please make sure you have a will, so all that hassle he does not need to go through.
It's a small price to pay now so that your son doesn't have to worry about all of these things in the future.
Yeah. And it's click of a button, so better to get it done. Thank you, Aditi. Thank you, Nikhil. Preeta, Chandar, and Shobha said it was very informative session today. A lot learned. So thank you so much.